We now come to the next segment of the IP regulations, which deal with the recognition of IPEs. So an IPE is an entity which can be a partnership, but it has to be a registered partnership, LLP or a company. If a majority of the partners of the LLP or partnership, registered partnership, are insolvency professionals, or a majority of the whole-time directors. Please star whole-time directors. Just as how I asked you to star registered partnership, are registered as insolvency professionals. As the case may be, a person eligible for, because there's another problem here. How can I be a whole-time director in a company if I'm also a chartered accountant in practice? Some of these need to be handled a little carefully. A person eligible under subregulation 1 will make an application for recognition as an IPE to the board in Form C. If you remember, Form A was application as an IP, Form B is certificate of registration, Form C is IPE's application, and Form D is called certificate of recognition. Okay? So the recognition shall be given in Form D. The recognition is subject to the conditions that it will satisfy the requirements in clause 12, regulation 12, which is the majority clause. Inform the board within 7 days where an insolvency professional ceases to be a director. Inform the board within 7 days where there is a new person who is joining in as a director or a partner. An IPE, please star both the 7. IPE shall be jointly and severally liable for all acts. Where the board is of the opinion that sufficient cause exists for the derecognition, it may do so by passing a reasoned order. Just to give you a small illustration, how do you exactly study? See here in this, what are my star points? I can have IPEs. It has to be a registered partnership, LLP, company. Majority of partners need to be IPs. Majority of whole-time directors have to be IPs. Form C, Form D, it's called certificate of recognition and not registration. Important conditions, any director or member joining, partner joining 7 days, leaving 7 days, joint and several liability of the IPE for act of omission of or commission of its partners and directors. And derecognition is possible through a reasoned order. With this, we move to the next part, which is the code of conduct for IPs. Now, it's fairly, before that, let me just do a quick recap on the statistics in this regulation. Who can be an IP? Certain positive, certain negative. Positive is passing the exams, national, LIE and criteria therefore. Can't be minor, can't be not resident in India, can't be of undischarged insolvent, can't be unsound mind, needs to be fit and proper. Then application Form A, that is Form A, there's only one schedule here, 7 days of receipt, 60 days is the overall time frame excluding time for rectification of defects. In case of refusal to grant certificate, you have to communicate within 45 days, give him 15 days time and within 30 days communicate your final order. Certificate is subject to certain conditions. You can have a limited period registration, 6 months, 5,000 rupees, valid for, last date for submission of that application was December 31st, 2016. After expiry, can't take up new cases, but old cases can continue. Temporary surrender is possible. IPA needs to tell the board within 7 days. DC is possible. This is DC by the board in this regulation. Okay. Based on an inspection or investigation, the DC happens. All the processes relating to the DC will apply. You can make IPEs, conditions associated with IPEs. After that, we come to the code of conduct for insolvency professional. Obviously, integrity, objectivity. So they can ask you a question where they talk about something that an IP has done. And then they say which part, where is this covered in the code? They will say part 1, part 3. and then they will say code of conduct. So you have to mark code of conduct. Integrity, objectivity. Go to sub-rule, go to 4. He shall not acquire directly or indirectly of any of the assets of the debtor or permit any relative to do so. Who all? IRP, RP, liquidator, BT cannot acquire assets by himself or with his relatives. Independence, impartiality, complete independence. Again, relatives cannot acquire. Pecuniary or personal relationship shall be disclosed. Professional competence, general guideline. Representation of correct facts and correcting misapprehensions he has to do. Timeliness. He must adhere to timelines under the code. Carefully plan his actions and properly communicate. Must not act malified or be negligent. Information management. He must undertake efforts to ensure that all communications are simple, clear and easily understood. Made well in advance. 17 is important. No private communication with any of the stakeholders unless required. Confidentiality. IP must ensure confidentiality. However, this does not prevent him from disclosing any information. That is regulation 21, that is code of conduct clause 21. What are the circumstances where you can disclose the information? If the party consents or it's required by law. Occupation, employability and restriction. This is star. They will ask you how many engagements an RP can take up. There's no limit. It only says if he is unlikely to be able to devote adequate time. But the tribunals have actually prevented certain RPs from taking up too many cases, especially when they were holding something like 50,000 crores, 2 cases. Then they said, please, you may not have the time. IP must not engage in any employment where he is unless he is temporarily surrendered. And he must not conduct any business which is inconsistent with the reputation of the profession. Again, the next one is star 25. IP must provide services for remuneration which is charged in a transparent manner. Circle. Reasonable reflection of work. Circle. Properly undertaken. Circle. Not inconsistent with the applicable regulations. He shall not accept any fees or charges other than those which are disclosed to and approved by the persons fixing his appointment. He shall disclose all costs towards insolvency process, etc. and must endeavor to ensure that the costs are not unreasonable. Which is why as an RP, if I have to appoint two registered valuers, I will take quotes and then appoint. So I need to prove that I discharged due propriety in determining the costs that are incurred. The whole thing is also because I have a fiduciary relationship. Gifts and hospitality. He must not accept any gifts or hospitality which undermines his independence. There it says or is relative. He shall not offer any gifts also. Then we come to second schedule, which is form A. The first schedule was the code of conduct. The second schedule has 4 forms: A, B, C, D. A, application for registration of IP. B, certificate of registration. C, application for registration as an IPE. And D, certificate of recognition. Go through these a bit casually. I mean, some of these, if you find there are any starred points, please mark those. With this, we come to an end of the insolvency professional regulations of the IBBI.